Hello.
Hello.
Hello, it's Justice Cook here. Can I know who's on the line?
Yes, Jonathan Fisher.
Thank you. Anybody else as yet?
Yes, good morning. Marwan Sakr is here. We are trying just to connect my colleague Jennifer also to the conference.
Good morning.
And Annalisa Day, I'm on the line, my lord.
Excellent.
And this is Abed Dagji from Deloitte Middle East. And also with me, Joseph Fadl, Muhammad Matar, and Anisa Aziz. And on the ME side, also Joanna Domian on the call.
All right, thank you very much. Well, perhaps you'll let me know when you're complete on all sides, and then we'll set some ground rules as to how we're going to conduct this hearing, how long you expect it to last, and whether we need a break and that sort of thing. Is either side complete at present?
My understanding, my lord, from our perspective, is that people have logged on but are muted. And so I think everybody is present, but is not necessarily able to speak or communicate.
Very good. Well, we're marginally early, aren't we? But perhaps you could just indicate, Mr. Fisher, from your perspective, what your anticipation is in terms of length of hearing and how it's going to work out. I've read all the papers, so you can take it that I'm very familiar with the issues and what arises. I think 4 hours have been set aside. I think that's right. But if we need all that time, then we may want to take a break in the middle. And the one thing I would ask anybody to do is, whenever they are speaking, is first of all to indicate who it is that is speaking.
Yes. So Jonathan Fisher speaking. My feeling is that I anticipate between 60 to 90 minutes, something of that sort, to talk you through our submissions.
Yes, very good. And Ms. Day?
I would anticipate no more than an hour in reply. It may be slightly shorter, but perhaps we might take a break between the submissions. I don't know, but I'm happy to play it by ear depending on how it goes.
All right. Well, it sounds to me as though we might take a break at about the 2 hour point, so to speak, just for 5 minutes or so people can stretch their legs, unless people think there's a need for any longer period at that stage. Self-evidently, in a telephone hearing of this kind, even if counsel thinks that their opponent is saying something that's absolutely outrageous, interruptions are very difficult to control. So, so far as is humanly possible, I would invite you to extend more than the usual courtesy that is normally extended to one's opponent. I'm sure you understand.
Yes, of course.
Yes, likewise.
Very good. Well, is there any reason now why you shouldn't begin, Mr. Fisher?
No, my lord, I'm very happy to. And it's quite clear that I can very briefly introduce everybody in this sense that I'm appearing for the appellants with Mr. Osman and Mr. Wright, Ms. Day is for the respondents with Mr. Murray. You have the documents and you've found them, I think, electronically enabled. And so I don't think, to take you through the bundle, simply to introduce the matter and say that this is an appeal from an order made in a CC hearing, and the order that's appealed against is one which orders the determination of 3 preliminary issues. And my lord, you have the appeal notice, the CMC order by the judicial officer, and the permission to appeal to this court. You have those. If I just give the page references in the bundle, we don't need to go to them. Pages 3, 10, and 13 will give you that little bundle of appeal documents.
Yes.
The scope of the court's work today, I would respectfully suggest, can be expressed in this way. We would say to you that there's a single dominant issue for the court to resolve this morning, and that is as follows. Is this a case in which it is safe and appropriate for the court to order a preliminary trial of one or more of the 3 issues identified by the respondents? And our submission, our answer to that question is, we say resoundingly no, and we say the court should resist the temptation to try any of the matters identified by the respondents as preliminary issues. There are other matters which have surfaced in the appeal, but we would say that they don't need to detain the court very long. The first matter is whether the judicial officer was obliged to give reasons for her decision on the holding of a preliminary hearing. We say respectfully that really this ought not to be a matter of dispute, because from our perspective, we would say it's obvious that reasons should have been given. We would say to you that in an application to hold a preliminary hearing, that's never a straightforward matter, and any discretion that the judicial officer will exercise must be exercised within a legal framework, and it's axiomatic that that framework is going to be something that this court would want to examine the application of the judicial officer's decision against that framework. In the absence of reasons, the court can't do that. And so we are left in a position this morning where we could say to you, we don't say to you, by the way, but we could say to you that there are occasions where the absence of reasons is enough to succeed on appeal, and then invite you to remit the case to another judicial officer, or for that matter, to Mr. Justice Field, who is going to be our trial judge. But we actually would say to you that remitting would simply add to the costs. And so we would say respectfully that this is a case where effectively the court is put in a situation where the court should consider the matter de novo, and it's the most expedient way to proceed. And in those circumstances, we would invite the court to do that. And that's why we say this matter really shouldn't, this aspect of the matter shouldn't detain the court. We should concentrate on the substantive issue. And that leads me to the second matter, which is...
Mr. Fisher, let me say at once that I'm not going to remit this matter. I'm going to decide it. So
thank you.
That will relieve your mind in that sense. And
yeah.
I take on board what you've said about absence of reasons. It means one can't grapple quite with what was the thinking, although in some cases an absence of reasons wouldn't matter at all, because it would be fairly obvious what the reasoning was.
Yes. No. Thank you very much. And so the second matter we may be able also to dispose of very swiftly. It relates to the admissibility of expert evidence on Lebanese law. You've seen in the papers that you have a report from the appellant's expert and a report from the respondent's experts. Those reports were not before the judicial officer because notification of the desire to seek a preliminary hearing came late in the run-up to the CMC. It's right to say that the parties have not seen eye to eye about the way in which this matter has come to be raised. But we do say it's significant for this hearing in this way, that both sides now have expert reports. We believe on our side of the virtual court that the evidence is helpful to you in approaching this dominant question, which we say the court has to decide, the substantive issue. We say that the requirements to adduce fresh evidence are satisfied, and we do note that there's no suggestion of any prejudice here to anybody. And we would say that without the expert reports, the court can have no real idea what it's going to be ordering in terms of the preliminary issues if it was minded to do so. Of course, we say it shouldn't be. But the reports are included in the bundle, and at this stage we suggest that you accept them de bene esse, and I can then move on and deal with the substantive matter in this hearing.
Well, I've read them de bene esse, so carry on.
Thank you. And so, if I may turn to the substance of this issue, the best way through it, we would suggest, is to talk you through the correspondence prior to the CMC. And the reason I'm suggesting that we do it this way is because I think it will help illuminate the issues to be viewed within the broader context of the case. And so can I suggest that we start, and I know that one of my juniors is going to do this for me, go to page, in the bundle, page 60, which is, we have the tabs, tab 18, but it's page 60.
Well, before you do that, Mr. Fisher, I'm always loath to read large quantities of correspondence between lawyers because they're often extremely unhelpful. But in terms of background, I mean, not only have I given a judgment on this case in the Court of Appeal, but I've also read Mr. Justice Giles's judgment, where two of the, quote, preliminary issues, unquote, were the subject of some discussion.
Yes.
I've seen in broad terms, without reading in detail, all the correspondence leading up to the CMC, but I know essentially the timing as to how the matters arose and so on and so forth, none of which goes to anything at all, does it really, save the question of admissibility of the evidence of Lebanese law. I mean, how is the correspondence going to help me is what I'm really asking.
Well, I certainly accept the judicial steer that I'm receiving, and the only way it would help, and it really would be to assist in understanding how the matter has arisen, how it arose late in the day. There's one aspect which I can explain to you, and it is part of our substantive submission, which is how there's been a lack of agreement about the quote-unquote agreed facts. But I can get to that in a different way. I don't have to take you through the correspondence in order to develop our position.
Well, I think I'd rather you did it in the alternative way, unless you feel that it really is going to assist you, your case, or me, and by going through the correspondence. But at the end of the day, obviously, you must take your own course, Mr. Fisher.
Well, thank you. Would it be of assistance if I move straight to the expert evidence and take you through that, and just make one or two points as I do that, because that is also very much part and parcel of what we have to look at today. In particular, starting with Professor Slim's report.
By all means.
Thank you. So Professor Slim, I think we find at page 673 of our bundle. And if I may make just a couple of points on the key sections of the evidence that we say are of significance, of particular significance. We have the report beginning at page 673. My Lord, just bears with me one moment whilst I organise my screens, so that this is a new skill that we're all developing. I want to just get the case documents across onto my screen. Right. Yes. Thank you. So, can I just check that you're seeing the same document that I've asked to go to Professor Slim's report at page 673?
Well, it's also page 618, which is, but it doesn't matter. I've got it both. I've actually printed it off as well as having it in electronic copy. But if you refer to the paragraphs, that's probably the easiest thing.
Thank you. I have to confess that I'm also working off a hard copy as well, but I have the electronic bundle in front of me. I was going to go straight to paragraph 20. Look at that. Where Professor Slim identifies that the issue of causation is absolutely critical to establish in this case. What essentially Professor Slim is saying is that on his understanding of Lebanese law, there are going to be some serious factual matters that have to be determined in looking at the recoverable loss issue. And I'm flagging up for the court paragraph 20, which really just contains in summary form those matters, 20, 21, 22. These are factual matters that will have to be determined in the event that Professor Slim is correct in his analysis of Lebanese law. And we can pick up a very similar thing if we go to paragraphs 31 and 30 and 31, because in relation to the question of supervisory fault and its impact on limitation, we can see again that there is a significant area, paragraphs 30 and 31, where we can see that factual matters will have to be developed in front of the court for a determination to be made. And the short point that I will obviously come back to in fleshing this out in our submissions is that that can't be done, and it's not appropriate for it to be done at a preliminary hearing. That's not what a preliminary hearing is all about. And so just on the expert evidence, expert evidence that Professor Slim is putting forward makes it clear that factual matters are very much in issue. And it's interesting just to consider the point about the distinction between supervisory fault and non-supervisory fault. We'll come to this with Mr. Mattar's evidence in a minute, but Professor Slim is very clear that there is that distinction to be made, and that impacts on the issue of what matters need to be determined for this matter to be resolved. Paragraph 32 is also in the same vein. So really I'm inviting you to take 30, 31 and 32 as high points in terms of the factual matters to be considered. If we look at Mr. Mattar's evidence, it's interesting to see, we would say, that on the issue of the way in which he approaches matters, he's very much taking an absolutist position, and in particular we see that at paragraph 2.1, which
yes, page 710.
Yes, 710, 711. We can see he takes a very absolutist position. But one of the things we would say about Mr. Mattar's approach is that he actually doesn't batten it down as tightly as perhaps is needed on the respondent's case. I mean, for example, we notice that when he talks about in the paragraph in the middle of that page, 71710, it's the second paragraph of paragraph 1.6, where he talks about, however, with respect to Professor Slim misses the point, I consider the matters which are pleaded and the agreed facts are prima facie sufficient for the court to decide the preliminary issue which arises under Article 178. I mean, we would just pick up on that and say, well, hold on a minute. You know, even on your case, you're talking about agreed facts which are prima facie sufficient. I'll come and develop the point in a minute that they're not agreed facts, but even on the respondent's case, that's not a basis for making a preliminary hearing, or if the facts are prima facie sufficient. That's dangerous. We also note that there's a little bit more of wiggle room that comes into Mr. Mattar's report. Paragraphs 1.3 and 1.4 at page 708, where there's a recognition that the determination and assessment of damage is left to the court's discretion on a case-by-case basis, and that causality exists whenever it's certain the damage was caused as a result of the wrongful deed. These are factual matters, even on this evidence. And so we do question whether the absolutist position is, even on Mr. Mattar's account, is a sufficiently sound basis. We also note in passing, we make a submission that we note that Mr. Mattar, there are various things he doesn't cover in his report. He doesn't actually, on the limitation issue, consider the date from which the limitation period is due to run. He doesn't actually ask the key question, which Professor Slim does tackle, namely whether the agreed facts are sufficient to deliver a ruling on these preliminary issues that are being put forward. And so we would say that, interesting though it is, the report actually doesn't take the respondents where they want to go. And we also note in passing that where Mr. Mattar has developed a strong position in almost absolutist terms, he really hasn't supported that with any authority. We see that for example, he says, I'm at page 712, the small 2 at the top of the page, where he says the auditor's mission is in essence a supervisory mission. Any fault committed by an auditor while exercising that supervisory mission is ipso facto a supervisory fault. There's no authority given for that. That plainly there's a dispute between the experts on it. But it's interesting to note that in the next paragraph, Mr. Mattar says, given that an auditor's liability is triggered by fault committed in the exercise of his audit mission, it's difficult to envisage a scenario in which auditors may be held liable for damages in respect of matters outside the scope of their duty. What he doesn't say is that it's impossible to do so. Again, there's just a little bit of wiggle room coming into that. And so again, we would say it's dangerous, even on Mr. Mattar's account, to proceed on the basis that there's a solid foundation for making preliminary rulings in this case. And so those were the matters that I was going to just mention. Because
Can I interrupt you for a moment, Mr. Fisher?
Yes.
When preliminary issues are tried, it doesn't matter whether one calls them, quote, preliminary issues or simply separates one lot of issues to be determined before another lot of issues, which frequently happens in large-scale litigation. There are a number of potential approaches. Obviously, the more facts that are agreed, the less likely it is that there is going to be a requirement for detailed factual evidence and factual inquiry and decision by the judge, and therefore it's more attractive in terms of looking at hearing some issues first because they'll be short and sweet. But here, the agreed facts, and subject to your caveat about one particular fact, I think, and perhaps more, not being agreed, the way in which the court would be looking at this would be to say, take the pleaded case of the claimant, the plaintiff, take the agreed facts, assume that the plaintiff claimant is going to establish the facts as pleaded. Now, on the issues as put forward of Lebanese law, is there a case that holds good or not? So I'm not sure at present that I understand quite what the problem is about the facts, because for the purpose of these preliminary issues, the court would simply have to assume that your pleaded case was the basis upon which it was proceeding. So it would assume those facts for this purpose, wouldn't it?
Well, yes and no. I'm going to, if I may, develop the submissions on both recoverable loss and limitation. It's not going to be possible, we say, to actually take that approach, because I'll show you where there is a dispute on the pleadings, certainly in relation to limitation, where you just can't say that we take the case at its highest. There is a dispute between the parties as to the date from which limitation starts to run. And so whilst it is possible, and I'm certainly not going to seek to persuade you that it would be impossible to carve out certain specific questions of law, they're not actually going to help in terms of shortening the trial, because they're not going to lead to a determinative or dispositive resolution. On the issue of recoverability, that's even more difficult, because even if we get to a point where the court will say, well, you know, this is the legal position in Lebanese law, the court's then still going to have to apply that law to the facts of the case. And we would say to you that on the facts of the case, it's not going to be sufficient to simply take the claimant's pleaded case, because it's one that is contested.
Well, no doubt you'll take me to that, but as I've read the pleadings, and I have read them, but perhaps not every single word, but as I've read it, the parties have said in their pleadings what are the relevant dates from which time runs.
Yes.
And obviously there are two potential dates that straddle the 5-year. I've forgotten what the Latin phrase is, but the period from which the limitation period runs, going back to July 2011. There are two dates there. There's an earlier date of the FinCEN report, which I think is the date that the claimants have identified as being the date when they first read the report, that they were aware of the money laundering scheme, as they put it. But what I need to understand, I think, Mr. Fisher, is this. Are we looking, for the purpose of the limitation argument, at a contest between specific dates when the loss and damage is alleged to have been suffered, or are there also questions of knowledge and discoverability that arise? And I've only detected the former in the pleadings thus far.
Yes, although that's right, but it's also right to say that the issue of knowledge and a question of concealment is something that did emerge during the hearing in front of Justice Roger Giles, and
yes.
And he refers to it. I don't think we're in a position. Yes,
I understand that entirely, but what he didn't have at that stage, of course, was a defence and a reply. And indeed, he had a slightly earlier version of the points of claim, I think. We now have defined pleadings. And so the reason I asked the question is that I hadn't detected that one of the questions which he'd raised, which was the possibility of concealment and so on, was in reality, as it now stands, an issue. But if I'm wrong about that, no doubt you'll take me to the relevant part of the pleadings. But if you could help me on those questions, that would be assist me. Obviously, you'll come to the reflective loss point in a moment, and deal with that in due course. I'll try not to interrupt further, Mr. Fisher.
Not at all. I'm very grateful for judicial intervention whenever it comes. It's very difficult to rule that out. There is a dispute between the parties as to whether or not the reports, the anti-money laundering, counter-terrorist financing reports, should have been shown to the appellants. And one of the questions that would arise is as to at what point they actually did have knowledge of what was going of the defaults, as it were, of the breaches, and so that issue is one which does hover in the case, and so it's going to be difficult, we would say, to make a determination at a preliminary stage in relation to we're talking about limitation now, without hearing evidence as to that. Normally in a situation like that, you would be calling evidence from the appellants, you would be calling evidence from the respondents, they would be cross-examined on that evidence, and that none of that's going to occur in a preliminary hearing, and that's one of our concerns. Can I attempt to address this in order and to say a few words about recoverable loss, and then to say a few words about limitation. So far as recoverable loss is concerned, the problem that we have, we would say, and here's what my Lord says about the pleadings, but there is still a problem, because the court will have a series of options if there is a preliminary hearing on this point. And one of those options that the court may come to is that Professor Slim is right in his assessment of Lebanese law. And the moment you reach that conclusion, we would say that the whole matter opens up. You can't determine the issue on the pleadings at that point, because there has to be an exploration of what type of breach has occurred, the nature and extent of the auditor's duties. We have set them out in the pleadings. I appreciate that. Of course we have. But the extent of those duties still will fall to be measured, because the court will be saying on the face of the pleading, well, on the claimant's case, the appellant's case, if we accept Professor Slim's view, the application for a preliminary determination effectively fails. So that being so, so it's not my submission that you couldn't do it, but our submission is that it just is not sensible and is not safe to do it, because why are we doing it? It should be done at trial if there's a realistic prospect that Professor Slim might be held to be right. And so
I'm not sure I understand that, Mr. Fisher, because again, on preliminary issues, it's the old-fashioned way of looking at preliminary issues was to say, well, if it's dispositive of the case, whichever way the finding goes, that speaks for itself. But if it's dispositive one way only, that still may be worth doing, as long as it doesn't require a repetition of all the same points all over again at the hearing. But if Professor Slim is right, and there's a distinction between supervisory breaches and so on and so forth, there's a distinction to be drawn, then in fact,
perhaps helpful to know that, isn't it? Even though, of course, it doesn't result in disposing of the claim. What's the downside?
Well, the downside is that we embark upon a preliminary hearing. We embark upon the costs of that, and we have that evidence in isolation, and it still leaves open the need to go through a trial process in order to determine the matter. So the question really is, look, it's a benefit analysis here, but if there's a real prospect that we're going to end up with a trial anyway, it would surely be better, we would say, to have this issue determined at the trial, to have a bifurcated hearing whereby we would split it up in this way. If it's going to be determinative, yes, one sees that. If it's going if we can be confident that it's not going to delay matters, it's not going to add to the cost of the matters, then one can see that too. But what my Lord has just said to me, I would suggest with respect, belies the problem, because what my Lord said is that the holding of the hearing to determine whether Slim or Matar are right, that may produce benefits, and that's the point. Well, of course it may, but we really can't be sure, and there's an equal prospect that it's actually going to do the opposite, because an issue like that, and we look at a number of the issues here, but it opens up a doubling of costs, because we have to have experts giving evidence almost certainly at a later stage. We're certainly going to have additional cost for the cost of the preliminary hearing, which would have been cheaper to do at the actual hearing. We will certainly delay the trial because of the time involved. We run the real risk of this going to the Court of Appeal again. This could delay, a preliminary hearing could delay the trial by a couple of years, and in so doing, significantly add to the cost. So, my Lord, again, we don't make submissions that are putting the court and saying to the court, you can't do this. Well, what we are saying is that it's really not safe to do it, and that's, my Lord, why I opened and tried to set the framework for our discussion within the context of safety. It's not safety, and within the context of appropriateness. It's not appropriate to do it, and it's neither safe nor appropriate, because at the end of the day, there's a real prospect that Professor Slim is right, and that we're going to be hearing all of these things at trial. And so whilst you might be able to carve out a particular issue and say, well, if we deal with this surgically, that will save time, that's not this case. And so that's our submission in answer to my Lord's question.
Yes, thank you.
The possibility, I appreciate we can't try now a form of view on the difference between Professor Slim and Mr. Matar, but I would suggest that I can submit to you that what I've just put to you, what we've posited on behalf of the appellants, is not a fanciful position at all. And I say that in this way, that Mr. Matar's position on this issue of whether or not the breaches are all going to be of a supervisory nature, we would just say, stepping back from that for a moment, that can't be right, because there must be cases where there are going to be breaches for which the auditor may well be liable, but which don't relate to the strict supervisory work that they're doing. I mean, we could posit an example, and I appreciate that examples are always taken as an extreme, but they do test the principle. We could take an example of an employee who loses his temper, an employee of the auditor loses his temper and hits a director of the company, or an employee that steals information. There would be an issue about liability. I'm not going to suggest one way or the other how that would be resolved. There would be an issue. I don't think anybody's going to disagree with that proposition. And once there's an issue, you would then be into saying, well, hold on a minute, those breaches are not breaches that actually come from a part of the supervisory function. So the short point that I'm making is that in saying to you that it's quite possible, distinct possibility, that Professor Slim is right. I mean, on our case, we'd say he is right, but just for the purposes of our discussion about whether to hold a preliminary hearing on this, it's certainly not fanciful. It's a real possibility, and therefore we end up with the additional expense that we'd all be going through anyway, and the 2-year delay that we would suffer as a result of this preliminary hearing. There is another aspect as well, which Mr. Matter doesn't deal with, but actually does come through Justice Roger Giles's judgment, and that is the issue, and I'm sure my Lord has picked it up, of whether there are exceptions to the reflexive loss rule. And perhaps, my Lord's indicated you've read the papers. I don't want to take any more time than necessary. If I just give you the reference to it, but where Justice Roger Giles deals with it at pages 590 to 593. And again, that's an intensely factual matter that you're not going to be able to resolve by just taking the position on the pleadings. And so we would say again, if you look at that, how can you, we would ask rhetorically, resolve that issue without evidence? The court may well come to the view at a preliminary hearing that there are exceptions to a reflexive loss principle. That's not our case, but we could see how a court could come to that view. Well, where's that going to get us, we would ask rhetorically, because we're still going to end up having a trial. So I think the short point that I'm trying to make is that whichever way you look at it, it's the help, the assistance that the parties are going to get from having a preliminary issue tried, in this case, whether it's on limitation or whether it's on recoverable loss, is actually going to be limited. And in terms of cost benefit, it's just not justified. Have a preliminary hearing where you can surgically excise a matter, but there's nothing surgical about this case. You're not going to be able to do that. And so we would say in those circumstances, it's too difficult to do, and in terms of cost, should not be done. And we would say, and perhaps in the, having developed it in that way, I don't really need to say. I've got submissions that I was going to develop about the pleadings and the dispute between the parties. Perhaps I can just deal with this matter, just to make it clear that there is an issue between us on the question of agreed fact. You'll recollect that amongst the agreed facts put forward in the preliminary issues document prepared by the respondents, that they make reference to the AML CTF reports. And they're saying that it's an agreed fact that these reports were prepared. On the pleadings, that's not right. We've made it absolutely clear. If you look at, again, perhaps I can give you the references rather than taking you to them.
Well, there are 2 points, aren't there, Mr. Fisher? One is whether they were prepared, and
Yes.
secondly, whether they should have been provided.
Yes, exactly. You have it. And so those points as well, you can't go into, is our submission, with the greatest respect, you can't go into preliminary hearing without a proper substratum of fact agreed, and you're taking the pleading as agreed, but it's actually not agreed, and it's being presented to you as if the position is agreed, but it's not. And so,
how does that work again, Mr. Fisher? As I understand it, the claimant's prepared to take that out as an agreed fact and say, well, that's an issue. So the court would have to proceed on the basis, because this is the way it could only proceed, on the basis that what you've pleaded is right, that in certain years the reports weren't done at all. I think I've understood that right. There are 2 years where you say you don't believe the reports were actually prepared. And in the other years, you say, well, you didn't get to see them, and you should have done. Or at least, I don't think you've actually pleaded that, but you haven't admitted. No, I may have got that slightly wrong. Perhaps you can just clarify what your case is, but you haven't specifically said that there was an obligation to provide them to the shareholders. I think that's what the position is, but you've not admitted. Have I got that right or wrong?
My Lord has it right. And what we are saying is that this is illustrative of the problem, that we shouldn't be going into a preliminary hearing.
Yeah.
We're already at a situation where a certain agreed fact has been put forward, and we now realise it isn't. And it's just dangerous. And we should heed the judicial warnings that I'm going to take you to in a minute, which just urge you to just exercise enormous caution, because in so many cases, and the law reports are replete with these examples.
Yes, the siren song, yes.
Well, yes, and judges go into it, and parties go into it. We see in one of the 2 cases that the parties were agreed, and they go into it thinking that it's actually going to be possible to sort of forensically deal with this at a point, and in fact it all goes wrong. And so, this is not a good omen to have the respondents putting forward something as agreed and it's not agreed. And that, I think, is really, in our submission, what I'm trying to put over to the court, that I'm not trying to persuade the court that it is not possible to hermetically seal an issue. I mean, we could hermetically seal the issue of whether or not DIFC law applies to determine limitation. I mean, that issue has to be determined at some point, because our discussion so far this morning has been predicated on the basis that it's all Lebanese law, but it just may not be. It may be DIFC law, at which point on our side of the court we will smile happily, and so that can be taken out. And yes, of course, you could set it as an exam question. It doesn't need to be dealt with in a court forum. But is it sensible to do that? Is it safe to do that? Is it going to really assist the resolution of this case when all it's going to do is delay it? What are we going to do? We'll be listing that in November, October, November. We'll be in the Court of Appeal, because be sure that one side or other is going to appeal that ruling. We'll be in the Court of Appeal in when? 2011, maybe, something like that, June. We won't have started on the disclosure process. We won't have got to exchange of evidence, but we will have a ruling by the middle of 2011, which is going to tell us one way or the other whether it's DIFC law or whether it's Lebanese law that applies to limitation. And we may well have exactly the same point on admissibility evidence, which law applies there. And how is this going to help us? It will be 2021, 2022. This is going to delay the trial, and it won't deliver for the court what the court wants to deliver. We understand what the court wants to deliver, and we want to get there as soon as possible as well. But going on a preliminary hearing is going to be a real sideshow that is not going to shorten matters at all. And that really is the burden of our submission. It's just not appropriate, it's not safe, and it's not appropriate. And that's how we come to this. Even if we take the DIFC law applying on limitation, I think it's agreed between us, I can take you to it, that the fraud claim would remain extant. It would certainly remain extant, and therefore, and again, we would say it's not just a flimsy possibility, it's not just fanciful that the court could rule that DIFC law applies to the limitation issue, and that, my Lord knows far more than I do about this. But that was the common law position before in England and Wales, before statute intervened. There's a fanciful point that we're making here, and so the delay to the trial will be significant. There will be a trial, and the delay to it and the additional cost is just going to multiply. And so,
can I just ask you this, Mr. Fisher, on that last question?
Yes.
Is it common ground between the parties that if limitation law is a matter of substantive law in Lebanon, then it applies or will be applied by the DIFC court? But if it's procedural law, as a matter of Lebanese law, then the DIFC court would apply its own limitation provisions.
Yes, I mean, I think the way we would argue it when the time comes is to say that it's the old common law position in England and Wales that would apply, and that would be our submission.
Yes.
Yes, and so therefore the point to bore my lord by repeating the same point, but I think my lord has the point. That, and we would say these are powerful points to take into account. Don't go into this lightly, because it's almost certainly going to actually cause more problems than you're seeking to solve. And that's our position. Thank you. The admissibility of evidence point, I would suggest...
This is entirely discrete, isn't it, from the other points, in a sense? Isn't this a matter that has to be resolved at some stage before the trial, regardless? Indeed, I mean, you need to know what your position is on this, don't you, in terms of admissibility?
Yes.
Because if you can't establish the money laundering scheme, so to speak, by reference to the findings that have been made by either FinCEN or ESCA or in the Licky litigation, then you're going to actually have to produce the evidence that demonstrates that. And in those circumstances, one would have thought you're going to have to do quite a lot of work, and the likelihood is that it would increase the length of the trial considerably. Am I wrong about that?
I said yes too soon. So I certainly go...
You can withdraw it at any point, Mr. Fisher.
So I certainly go with you, my lord, on this point, that it needs to be resolved. The issue that's been raised by the respondents needs to be resolved before the trial. We certainly don't go with you on this point that we need it resolved in order to prove money laundering. Our case is very much that what's happened here is that the auditors have failed in their to discharge their obligations to undertake money laundering, counter-terrorist financing audits, checks to look for that. And the question is why they did that. Did they do that because they were simply incompetent or reckless, or was there something more malign? And that's our case. So we don't actually have to go as far as to saying we need that FinCEN report in, because if we don't have that in, we can't prove money laundering. It's plainly part of the narrative as to what happened, and certainly there is a discussion that we will have, and the parties will no doubt view differently the probative value to be taken from the FinCEN report and the ESCA intervention. And that of course, is going to be a point of divide. And yes, it does need to be resolved before, for example, we get to a point where I open the case. And we see that. But look, the point is that we would say respectfully, issues of admissibility and also the weight and the probative value of evidence. I mean, it turns on the issues of relevance. It's an obvious point to make, trite point to make. But then we would ask rhetorically, well, how is the question of relevance really to be determined? And the answer is you would determine it. It would be the trial judge who would determine it, who has, by that stage, a full understanding of the facts. And it may well be that you would want not just witness statements, you'd also want disclosure, so that the trial judge would be able to form a view, a holistic view, a comprehensive view of this issue, because it's not simply Is it admissible? Is it not? In terms of admissibility, we have to look at relevance, we have to look at weight, etc. All those factors that the court is familiar with. And so we say that, yes, of course it needs to be resolved, but this isn't a preliminary hearing matter. It's a matter that should be resolved by the trial judge, the assigned judge, who, at the point when he deals with it, he has a good understanding, a detailed understanding of the issues in the case as illustrated or developed by witness statements and disclosure. And it's certainly incapable of being dispositive. And the preliminary issue mechanism is simply not apposite for a resolution of this issue. Again, we could carve out the legal issue. What rules to apply? Are we going to say that it's a DIFC law, or do we say it's the law or that's being applied to the substantive matter? And there's an argument there, and the arguments may well fall differently to the argument on limitation. I appreciate that. But there is an argument to be made. Yes, you could carve that out and say, right, we know it's going to be Lebanese law, it's going to be DIFC law, it's going to apply to determine whether or not this evidence is admissible. But that is just the beginning of the story. It's certainly not the end of the story. And yes, we appreciate it needs to be done pre-trial, but not at the preliminary stage, to be done by the trial judge. Those are our submissions on the admissibility point.
Can I just ask this, because I don't think I've analysed the pleadings for this purpose. Do you need to show, for the purposes of your case, that there was actual infringement of the regulations, AMF, CTL, and so on and so forth, or simply that the auditors failed to pick up matters which were of concern in that regard, and the effect of not doing that was to lead to the implosion of the bank?
Yes, I mean, it's plainly the latter, but with this caveat, in the sense that the stronger the evidence is that there was money laundering, the more obvious it should have been to the auditors if you take the view that there wasn't something malign going on. So let's just take this case at its lower threshold and say, well, it's a case of negligence. So we don't have to prove that there was money laundering to get the negligence point, the fault out. But the stronger the evidence of money laundering there is, the stronger our case on negligence becomes. So that's the answer I would give, my lord.
Yes, and you need the actual money laundering for, do you not, for the purpose of your case in dishonesty?
I don't think that necessarily follows. Again, on the sliding scale of culpability, the stronger the position is in terms of establishing money laundering, the stronger our case is in that sense in terms of negligence and in terms of fraud. But I would suggest, obviously, we're discussing the matter at this point in interlocutory proceedings, but I don't think we would need to have that position. I don't think we need to take the highest position, i.e. proof that there was money laundering. You could still have two parties, an auditor who's in league with directors of a bank who agree between them that they're not going to do anti-money laundering and counter-terrorist financing auditing because they're concerned about the risk emerging that procedures aren't in place. Doesn't mean to say that there was money laundering. I mean, our case, of course, is. I mean, it's obvious. We don't seek to go behind the FinCEN report for one moment. We're not saying that. But I don't think we need to go as far as my lord is positing to say that we have to prove money laundering to get any aspect of our case, negligence or fraud, home.
There, I suppose, two questions of dishonesty here, and again, I probably haven't analysed the pleading sufficiently closely, but there's the dishonesty in the opinion that's furnished by the auditors, that you've clearly pleaded. And for that purpose, as I understand your case, as you now have explained it, you wouldn't need to show necessarily that there had been actual infringement.
Yes.
It's simply, as you say, effectively a blind eye conspiracy not to carry out the necessary inquiries.
Yeah.
If your case goes further than that in terms of dishonesty, of being privy to actual money laundering itself, obviously you need to show the money laundering.
Yes, and of course, on any view, what happened, FinCEN report, FinCEN process, and what the narrative from the United States and the narrative from ESCA, the Emirates Securities body. I mean, that's part and parcel of what happened. And so it plainly has an obvious relevance. The question is how much. And I mean, it's all those issues that were surfaced in we've got the case in the bundle, actually. I think my learned friends put it in, on how far it was the aviation report and the underlying evidence and how much you take into account. I mean, all of that is ground. It's fertile ground that we will be going over. We'll be traversing it. But traversing it as a preliminary issue is not the right issue. It's the trial judge's role to be able to do that, and the trial judge will be in the best position to do it. And so, but only after all of these matters have surfaced, only after we've got all the evidence out and the disclosure out, and then we can see exactly where this lands. It's dangerous to do it otherwise.
Understood, but I suppose I need to ask you this one question. What is the answer to the Hollington and Hewthorne point?
Well, on any view, it's part of the narrative of what happened. So that's a short and simple answer. That it's adduced on the basis that it explains the narrative. So I mean, the Hollington-Hewthorne point goes to what does it go beyond that to prove, and that's a matter that will be subject to further submission, and we would develop our submission accordingly. But we haven't dealt with the substantive issue on that because it plainly would be premature to do so.
Okay. Understood. Thank you.
Thank you. Failure to give reasons I've already dealt with, and I wasn't proposing to say any more on that, unless my Lord would like me to. I mean, I note the points taken against us about discretion, and there's I think one.
Well, if I just intimate to you the way I see it, and then if you want to say anything more and persuade me otherwise, then do. I mean, the way I see it is pretty straightforward, really. There are some forms of case management decisions where there's absolutely no need to give reasons, because if you're saying 7 days instead of 10 days extension or whatever, the background is such that there's no need to give reasons of any kind. Case management decisions are peculiarly difficult to appeal, and there are special provisions in the rules in the DIFC that make that harder. But in the ordinary way, if there is a decision which involves a degree of argument and weighing of factors and the like, then you would expect there to be reasons. And the authorities give you two bases for that. One is that it is a very good judicial discipline to apply one's mind. And secondly, and just as important, if anybody is coming to look at it, whether a party or a court of appeal, they need to know why a decision has been reached. And I do take the view myself that when ordering preliminary issues in the face of a case of this size and the arguments that were put forward, there was a need to give reasons.
Yes.
So that's the way I see it. So I wouldn't personally allow an appeal simply on the basis there were no reasons here, but one would have to look at it and see the nature of the decision and what there was. And the reality is I'm going to have to take my own view
Yes.
about whether or not the preliminary issues are an appropriate thing or not, without the benefit, in the sense of being simply able to say this is a review decision of a case management decision.
Yes. My Lord, yes, and I'm certainly not going to seek to push at any open door. We respectfully endorse that approach. It's entirely consistent with our submissions. And the only thing I was going to add, but my Lord has added it, I was going to suggest to my Lord that in the case of a preliminary hearing, that this is just the sort of case where reasons should be given because there's a clear framework. We have the steel and steel criteria, have 10 criteria, and there's discretion here, and of course, but it has to be exercised within a framework. And so this is par excellence an example of a case where...
Well, I don't, as I say, I think in a case of this kind, it was required. It should have been done.
Yeah.
But having said all that, your submissions in writing have rather ignored or overlooked what I usually refer to as the Edwards and Bairstow test, which is it isn't a review court is not entitled to enter into the exercise of saying the factors have been weighed inappropriately. We would have weighed them a different way. A review court can only interfere in the ordinary way where reasons have been expressed on the basis that the lower court has taken into account factors it shouldn't have taken into account, has failed to take into account factors that it ought to have taken into account, or it has reached a conclusion that is perverse, that no reasonable tribunal directing itself aright could have reached. It's the classic review function. But because there aren't reasons here, one can't adopt that approach. And that's your best point there. This court has got to consider the matter afresh because it can't do anything else.
Yes, my Lord, indeed. I mean, it is the classic judicial review position that two different decisions can be reached, and they can both be reasonable. But equally, you can have decisions which are completely perverse. And in fairness to those who are with me, and we all take responsibility for this on our side and our legal team, we had sought to sort of to deal with that in the skeletons in our paperwork. Because I think our point was really, as the way we see it, we think that it's not safe and not appropriate to order a preliminary hearing here. And when you look at all the facts in this case, the element of discretion is really small. Applying the steel and steel criteria, those criteria must have been, in our submission, misapplied. We don't know quite which ones were misapplied, but they must have been misapplied, otherwise we wouldn't be in this position. I think
it probably doesn't matter in the overall context, Mr. Fisher, because as I say, I've got to reach a decision on this.
Yes.
So there we are. Yeah.
I don't know whether I need to take you to any law. I mean, obviously you're very familiar with steel and steel and the criteria. I mean, I don't know if you'll be assisted by being reminded of it, and indeed even just the head note sets out the 10 criteria and how they were applied. There are certain things that are interesting to note about...
Well, it's set out in one person's skeleton or another somewhere, isn't it, as I recall?
Well, I know, but I think I'd urge you to look at it's in our law bundle, and maybe if I just flag it up and indicate
go on.
What we're relying on. I mean, it's page 49, 50, where the head note is actually quite interesting because it applies the 10 criteria very thoroughly, and it is noteworthy that actually it was a limitation issue that caused the problem there, notwithstanding it being what you might think could, on the face of it, be thought to be something that surgically possible to deal with. In fact, it proved to be not the case. And then I would urge you to read pages 52, 53, and 54, setting out the 10 criteria. and of course the warnings there. Can I also invite you just to? It's very difficult. I don't want to sound as if our submission is that the whole of the Western world is going to collapse if you come to a different view. But I mean, we really do urge you to take on board, Lord Wilberforce in Tilling and Whiteman, at page 24, which we have here in our.
I'm so sorry, I didn't grasp that reference.
No, it's Lord Wilberforce.
Yes.
So let me just find it. There's Lord Wilberforce at page 24 of our bundle, the bottom of the page, where he really warns against having these preliminary hearings and talks about cases being exceptional, should only do it where the legal issue is short and easily decided. I mean, that's not this case, with the greatest of respect. We also have, I would just make this point, that we also do have the foreign law element. And again, I'm not suggesting that we shouldn't, that the court shouldn't make any preliminary hearing where there's a foreign law issue. But it's a complex matter. There's complexity in this case. You have to first of all determine which law is to apply, certainly on limitation and the evidence issue. You've then got to determine what that law is, second question. You've then got to apply that law to facts which may or may not be agreed. This is not a case that fits Lord Wilberforce's legal issue short and easily decided, and the foreign law element does complicate it. We also have Lord Scarman saying, be very careful, at page 32 of our bundle, where he says that he talks about preliminary points of law are often treacherous shortcuts, and their price is as here, and here being the Tilling and Whiteman, delay, anxiety, and expense. We say that's us. We really do. And we also mention Rossetti at page 105 of our bundle. Again, not going to go through it because my lord is familiar with it, but at the beginning of the Master of the Rolls' judgment, yet another cautionary tale. It's as if the Court of Appeal is sighing with hearing this again. It demonstrates that while often attractive, and my lord, that's what you're saying to me. This is attractive to deal with this. It looks it that the siren song of agreeing or ordering preliminary issues should normally be resisted. This is not a straightforward case. It should be resisted, would be our interjection. And so we would say if there are nonetheless to be preliminary issues, it's vital the issues themselves and the agreed facts or assumptions on which they're based are simply, clearly and precisely formulated. You can't do that here. That's not this case. And so the issue should be answered in a clear and precise way. It's a struggle to do that. And so we do mention that. And then very recently, there's been another decision, actually. Shan Panesar, page, and it's one bit of judgment that I wanted to mention to you. It's at page 453, if my lord just bears with me a moment. It's probably now the time. It becomes obvious that I am working on the hard copy files. It's 453 is the reference. No, it's not 453, is it? That takes you to Lebanon Marshall. Well, bear with me a moment, please. It's at 439. Let me just see. Lord, I'm sorry. 1 second.
That's all right.
I now have it. It's at. Oh, it is at 453, 452, and 453. So the passage I wanted to mention to you was really just again paragraph 66, actually, which just yet another cautionary tale. So echoing what was said in Rossetti. So we are saying that to you. We are saying it's just not safe. It's just not appropriate. It's going to delay matters. We appreciate. I mean, we understand full well my learned friend is going to immediately follow and say, Mr. Stobwasser, £500,000, and we understand that of course is what we are recognising. But all that does is grasp the reality of the fact that two significant parties are engaged in high-level civil litigation. It's an expensive business. That $500,000 is going to have to be spent one way or the other. Let's spend it this year or next year and not in 2022 or 2023, because that's what's going to happen. All that's going to happen if my learned friend gets that way is that we will delay this trial. Please don't do that. We would like to bring it on. Lord, I don't know if I can help you any further. I indicated I'd be about 60 to 90 minutes, and I can see that I've been 75.
Well done.
Is there anything else I can say to assist you?
No, I don't think so at this stage. Thank you very much indeed. I'll hear from Ms. Day.
Thank you.
Yes, Ms. Day.
Thank you, my lord. If I could start by dealing with the issues that you've debated with Mr. Fisher about reasons and the way in which you exercise your discretion very briefly, because obviously I'm big enough to see which way the wind is blowing, and I think you very helpfully outlined your thoughts on that, so I don't want to waste time on it. I think we had objected to the suggestion, which was definitely made, that reasons alone were sufficient to allow the appeal. And we obviously say that isn't right. And as a matter of technicality, English and Emery obviously says reasons not being provided in and of themselves is not a sufficient ground alone to allow an appeal from this sort of decision. We can also appreciate why you'd want to revisit the decision that was made, because you don't have any reasons, and obviously at a certain point in time we thought those were to be provided, and obviously for whatever reason they haven't been. So I don't know
why. I don't know why the reasons weren't provided when they were at one stage said that they would follow, but it may be. Well, I don't know why at all. It seems slightly odd to me, and I'll for future purposes in the court I will make inquiries to ensure that it doesn't happen again in a case of this kind. But there it is.
But we are
where we are, Ms. Day, and the reality is that I have to reach a decision of some kind in relation to this, and therefore, effectively, I'm looking at it de novo rather than simply as a review function, though I can bear in mind that someone else has taken the view that it was appropriate.
Yes, absolutely. And I think that was about to be my next submission, that whilst I appreciate without reasons it's more difficult, it still is true that she listened to a full day of submission and made a decision that there should be a preliminary issue. And we say that was for good reason, because we say when you look at the S.A.L test, it's overwhelmingly met here in relation to all three of the topics that we've identified, in a sense that I'll come on to the admissibility point, is in a sense more an issue of case management. But what we say in brief is that these are all issues which are self-contained, and I will take you to the pleadings. It is telling that you haven't been taken to the pleadings at all yet. They are defined on the pleading, and they will consist either of legal submission or relatively short self-contained points of Lebanese law, which will be heard by the experts. And again, if you've read Justice Giles's judgment, you will have seen that he found that it might be a sensible way forward to have some of this determined, but his concern was on a summary judgment basis. He couldn't say that there was no real prospect of these claims succeeding. And certainly, for example, in relation to the reflective loss issue, he didn't have any Lebanese evidence at all before him. And of course, he had to determine whether substantive law was Lebanese law or DIFC law. And now he's done that. Obviously, we are where we are. And so for the first time, in a sense, the court has the battle lines drawn. So I wondered if I could... Yeah.
Before you go there, two things. Justice Giles had before him Lebanese law evidence, which he thought was rather inadequate, did he not?
He had some. It's fair to say it evolved during the course of the proceedings as people serve reports backwards and forwards. Yes, he
thought it was inadequate in a sense because it didn't grapple with enough of the issues, and he thought, in particular, no one had mentioned the question of exceptions to reflective loss, and they still haven't, as matters currently stand. And therefore, he thought it was inappropriate to give summary judgment. But he did have that, and on the face of it, everybody has known since then, even if not before, just how critical Lebanese law might be. But leaving that point aside for the moment, if preliminary issues, if these issues that you have set out in your schedule were to be taken, do you accept that to the extent to which there are not agreed facts, the case would have to proceed on the basis of the point of claim, the claim submissions?
Yes, no, I do. We do accept that, which is why we've identified the issues by reference to the pleadings. So, for example, taking the reflective loss point, there's a very short point that we seek to have determined. If it's determined in our favour, it will be the end of the case. If it's not determined, it will be an issue that's off the table for trial. But it's a discrete, self-contained point. And I'm going to put it as colloquially as possible as to whether Lebanese law contains the same principles as English law in relation to reflective loss, and therefore whether these claimants actually have standing to bring the claim. You will see, and you will see in a sense, you've actually seen now, you've got the benefit of seeing Mr. Mattar and Professor Slim have outlined in a sense, and you will see in particular that Mr. Mattar talks about the relevant provisions. And there is an exception under Lebanese law too for where the company hasn't brought a claim. And obviously that will need to be explored in more detail. And one of the things that Justice Giles very much wanted to hear was to be able to cross-examine the Lebanese experts. And that's one of the reasons why he felt he couldn't decide on the papers what the answer was. But in my submission, that is something that it's a classic preliminary issue. It should be determined as soon as possible, because if this case, if we win, and it is dispositive of the entire case, and one doesn't need to look at all the wider issues raised by Mr. Fisher and by Professor Slim about causation, wider issues of loss. So in a sense, and Mr. Federagoli in his witness statement accepted that he had no objection to what we'd set out in the agreed statement of facts. So it is that discrete question of whether as a matter of law, under Lebanese law, are the claimant's claims, is the claim loss recoverable as a matter of law?
Yeah, I mean, the bottom line here, putting it bluntly, is this, Ms. Day, isn't it? Are there fact-sensitive issues which arise here which mean that determination of the points that you've outlined will in practice not achieve the result that you wish? Now, to take the obvious example, if there are indeed exceptions in Lebanese law to the reflective loss position that you espouse, then it might be necessary to look at all the facts and determine the facts to see whether or not one of those exceptions was called into play. Now, what's odd to me, the glaring omission in both Mr. Slim, Professor Slim, beg his pardon, and Mr. Mattar's evidence is that neither of them suggest that there are any exceptions. One says the principle simply doesn't apply. Direct and indirect loss is recoverable. That's Professor Slim's position. And Mr. Matter's position is there is effectively an absolute rule of reflective loss.
Yes.
But if there are exceptions to it, then one would be in a different, potentially in a different ballpark. The very fact that troubled Mr. Justice Giles would trouble this court too, in thinking, well, if that's what the ultimate conclusion is, have we advanced the matter very much further by having a preliminary issue?
Well, my lord, that's where it is important, and perhaps we can look at the pleadings, because the claimants put forward no alternative case that if there is a principle, they fall within the exceptions. And as you've outlined, this is something they've been aware of since Justice Giles's decision. So they very much put their eggs in the entire basket of saying the reflective loss rule simply does not exist as a matter of Lebanese law. That is their point on that. They don't advance any positive case to the effect of, if we're wrong on that, these are the exceptions and we fall within them. And that would be their burden to prove. And we are entitled, in my submission, to work on the basis of these pleadings. You've seen how long it has taken to get to this stage, and many rounds of amendments within these pleadings. So with respect, in my submission, the court and we, as the defendants to this claim, are entitled to work on the basis of the pleaded claim. So if I might show you how this arises in the pleadings, and if I can start the defense, please. Which should
now, you may have to go slightly slower here, because I didn't print off all the pleadings. I've read them electronically, and I've marked up various parts of them. But you may have to go slightly slowly in taking me to the relevant pages on the electronic version.
Okay. Well, I hope somebody at my end can change the pages for me, but it should be in the second hearing bundle, tab 14, and it should be paragraph 8.2 of the defence, which is at 1-240.
Page 240?
240, yes.
Bear with me a moment, sorry.
I'm hoping, my lord, that one of my team, you should have a message on your screen that says she's directed you to the correct page. But
well, no, I'm afraid I've done something. I had a problem getting into the case management system.
Oh, okay.
So what happened was that I was sent a compressed file, which I have downloaded. So I have my own version, which is obviously the same pagination, but it means that you can't direct me to it. I have to scroll down to get to it myself, and I'm plainly slower than others might be. Anyway, we're nearly there. Apologies.
Don't worry. We're very grateful to you for doing this remotely so that we don't have to wait yet further.
Yes, well, that's something that at some point I will ask you about, as to what the effect of orders in either direction might be in terms of dates and so on at the end of the day.
Yes.
Right, so which paragraph am I in now?
It should be paragraph 8.2 on page 1-240.
Yes, yes.
And we're in the defence, and you will see that we have a heading, no recovery for reflective loss.
Yeah.
And set up there, no standing for the losses, because any such claim belongs to LCB itself, may not be brought by individual shareholders in their own right.
Yeah.
And then if you go forward in this same document to page 256, which is page 294 of the same bundle, that simply repeats the losses which the claimants claim to have suffered are reflective of losses suffered by LCB and are not recoverable by the claimants in their personal capacity.
Paragraph again.
256, my lord.
Yes, got it.
And then, so that's the defence that we raised. Obviously, it's our defence to raise. It wasn't dealt with in the re-amended particulars of claim. And then we see the reply is in the same bundle, tab 16. And if I can take you, please, to page 46, sorry, paragraph 46 and 47, which is on page 322. Do you have that, my lord?
Slowly. Yes, I'm there now. Yeah.
Paragraph 46. You will see said there, it's averred that the losses suffered by the claimants are recoverable as a matter of Lebanese law. So that's the issue one. Is there a principle of reflective loss in Lebanese law or not? To the extent that there are any provisions of Lebanese law equivalent to reflective loss, which is not admitted, they do not prevent the claimant's losses from being recoverable. Indirect losses can be claimed under Article 261 of the Lebanese Code of Obligations and Contracts. So those define the issues between the parties, which you will have seen are then addressed in the reports that you now have. And that is the choice that the court is asked to make and decide who's right and who's wrong about that issue. So, my lord, there isn't actually any pleaded case that there's an exception, even in the alternative, there's some kind of exception and that they fall within it.
Yes, well, this is the one area where your plea wasn't, to my mind, adequate. When you pleaded your no recovery for reflective loss, you didn't give any details of Lebanese law at all. And when a request was made for further information, you simply said not entitled as a matter of evidence. I mean, there's always a slight problem with foreign law as to how much you plead and how much you don't, but the requirements are that you should plead any provisions of foreign law that you rely on, and one would expect reference to any statute that was referred to, or at least some provision that gives the essence of what your case is about. Whereas, in fact, as I understood it, you didn't really plead that at all. Am I right?
Well, it's correct that we said that will be dealt with in expert evidence, but you will understand that the parties have also been through the process that they have already. So in a sense, and certainly our refusal to answer it was never pursued in terms of saying, well, we don't understand it. But my lord, if this is felt to be an issue, it's still sensible from a case management point of view, which ultimately this is about case management. That is an issue.
I understand the point, but
that is an issue which, in my submission, can and should be properly formulated, and we shouldn't be prevented from having not being able to deal with this in a preliminary issue way by reason of that. And if it's necessary for the claimants to identify whether they do or don't rely on the exception, and thereafter to ensure that there is evidence to deal with that, then if necessary, then that can be dealt with, because the only issues here would be, they wouldn't be contested facts like concealment or date of knowledge. They would be simply what's happened to the company and why the company potentially hasn't pursued it etc. But the first thing would be, in my submission, for the claimants to set out whether they do actually fall within any exceptions. But in my submission, this is an issue, my lord, which is crying out for preliminary determination, and we shouldn't be handicapped by the failure of the claimants to engage with our agreed facts, which you will have seen. It was only in the witness statement of Mr. Fedrigoli that they what they said in relation to this was that our assumed facts were fine on the issue of reflective loss. And the point that they raise in Professor Slim's report is not that they fall within an exception, but that the court has to deal with the issue of causation. So whilst I take on board your concern that we didn't plead it as fully as we could, equally, you do now have the benefit of Professor Slim's report, and he doesn't outline that they wish to rely on any exceptions. And there's been no suggestion until you raised it that that would be an issue. If it was felt sensible that that should be an issue, then in my submission that can be dealt with by way of appropriate directions for the preliminary issue. But in my submission, it doesn't stop this from being an issue that can and should be determined at an early stage. As I say, it will either result in this being able to proceed, or it won't be an issue at trial. So one of the things that's said by Mr. Fisher is you'll have a rerun at trial. Because if we lose on it, it's an issue that comes off the table, so it will shorten the trial length because it won't need to be dealt with again.
Yes, the point that concerns me here is this, Ms. Day.
Yes.
Whereas the limitation point appears to me to have been fully pleaded out on both sides by reference to different provisions of the various Lebanese codes. And in the end, the argument seems to turn quite simply upon whether or not the provisions that relate to auditors are comprehensive, so to speak, and there's no room for going outside them, whether in relation to duties or limitation. That seems to be perfectly well pleaded. As matters stand on the reflective loss, despite the fact that Mr. Justice Giles was conscious of the possibility of exceptions from reflective loss, neither party has engaged with that or suggested that there are any. It's either a black and white position that there is a prohibition on reflective loss, or there is none at all. And if the position were to emerge that there were some exceptions, then how much further on are we as a result of having the preliminary issues determined if the court then has to try and apply what has been said by the experts to a whole set of facts which no one had plainly in mind at the time? In other words, you have a highly fact-sensitive inquiry once you get there. That's my concern. Now, the question I have for you is this: am I entitled to proceed on the basis that because neither party has mentioned the question of exceptions, and by that I mean don't just mean pleadings, I mean in Professor Slim and Mr. Matter, I'm entitled to proceed on the basis that no one's going to be saying that that is the case?
Yes, my lord. In my submission, you are, and in a sense, that's why it's helpful that the claimants applied and adduced the evidence of Professor Slim. And obviously, we've replied to Benny S.A. to seek to be helpful on that and to outline to the court what the issues would be on a preliminary issue. And so, in a sense, you can tell at this stage that that isn't contended for by either expert. So, in a sense, it's although in English law it's and other jurisdictions it has been applied, certainly under Lebanese law it hasn't been applied. So you in my submission, you can take the view that the pleadings perhaps didn't outline it in as much detail as might have been desirable. That has now been cured by the reports that you have, and those reports that you have do not say that there are any exceptions. So therefore your concern simply doesn't arise, and in fact you're in a better position now than the judge at the CMC because you have the benefit of that.
Yeah.
So, my lord, I don't know if there's anything else that I can say to assist you on the recoverability of loss point. But we do say this is a sort of classic preliminary issue. It's something that Judge Giles himself said, if this had come before me on a preliminary issue, it would be a different story. It plainly isn't right to make this matter go to a full hearing without this issue being determined definitively one way or the other. It will either dispose of the entire action or it will take it off the table and therefore shorten the trial length of the judge who will be dealing with it. And because we have now applied, the claimants opposed this, but we successfully applied for this case to be transferred to the TCD. We very much hope that Mr. Justice Field will now be hearing this, and we will have some continuity of a judge who can hear it all the way through, so to speak. So in a sense, just as you've got the benefit now of having heard this case on a number of occasions, obviously that is an additional advantage because we are now in the TCD, and for a case of this complexity and size, that's obviously advantageous. So, my lord, those are my submissions on the first issue that we raised as being for a preliminary issue. Limitation, from what you've said, it sounds as if you have looked at the pleadings. I can take you to them, but we say it is very clearly set out the different issues that arise, and these are set out. It was something that the claimants tackled in their re-amended particulars of claim. So perhaps if we might just go there first of all, which should be in the first bundle for the hearing. At page 170, it's paragraph 325.
Page reference again.
170, paragraph 325.
Thank you.
And 325 is obviously the first question which arises, which is simply a question of law and submission, namely whether limitation is governed by DIFC law or Lebanese law. And again, in my submission, that is a question which can and should be determined at the earliest opportunity in this case, because what is the point of going to a trial where you're having to run two cases on limitation, one on S.A.L law and one on Lebanese law? So that is a question in my submission which plainly doesn't involve any evidence and should be determined as soon as possible. And then you will see at 325, the claimants say that this is a question of DIFC law, and they have set out there the different periods that they say apply in relation to deceit and in relation to Article 38, obviously identifying the date on which they say they suffered loss. And you will see in the preliminary issues as we frame them, we recognise the tests that apply under preliminary issues, and therefore deceit is not on the table for a preliminary issue, because we recognise that that will involve significant factual inquiry. But whereas the second point does not, it's just about the date which is appropriate to be used. And then under Lebanese law at paragraph 326, again, we have the battle lines drawn about whether the limitation period under Lebanese law is 10 years or 5 years, and then if it's 5 years, from which date it runs. And then you will see in our defence, if you go back to the second case management bundle.
Well, let's just stop there for a moment.
Yes.
The competition for dates from which the period is to run are what?
So the competition is, if you look at paragraph 325.2.
Yeah.
So the first dates, they actually refer back to 169 and 170 of the pleadings.
Yeah.
And that's when they set out the date of the General Assembly, so 28th of July 2011.
Yeah, that's the approval of the sale to SGBI and the liquidation of LCB.
Correct. And then there's an alternative date they give, which is the date of the FinCEN notice.
Yes.
So that's under DIFC law, and then under Lebanese law. Obviously, their primary case under Lebanese law is it's a 10-year period, so the date would become irrelevant. And then the alternative is 326.2. The alternative is, again, based on the 28th of July, so the liquidation date.
Yes. And, yeah, go on. You're now
and
going to take...
the 28th of July is consistent throughout the remainder of paragraph 326.4.
Yes. And in the defence, which you're now going to take me to...
Yes. In the defence, which is bundle 2, page 295,
yeah,
we say that the date, regardless of the basis on which the claim is brought, is 5 years, beginning in respect of each year's audit on the date of the shareholders' meeting at which the relevant audit report was submitted.
Sorry, I'm just getting there. This is paragraph 265, is it?
It is, my lord.
Yeah.
So that is the issue of law which we ask the court to determine at as early a stage as possible. It's not an issue of fact that arises. And once that is determined, it will be determined whether the claim is statute barred or not, or bits of it are statute barred, and then it can proceed to a trial on the basis of all allegations that are within time or none of them, depending on the outcome of that investigation. But again, that is clearly something which can and should be determined at as early a stage as possible.
Can you just give me the last date that is relevant for paragraph 265.3 in relation, I think, to the 2010 year?
So that's set out at 8.2, sorry, 8.1, which is back at 240 of the same bundle.
Yeah.
It was the 26th of May 2010.
Yeah. Yeah.
And then, just for the sake of completeness, my lord, the reply then doesn't really take matters much further, or doesn't take issue with these points. If you look at the reply and look at paragraph 61, please, which should be on page 328.
Yeah.
So this responds to paragraph 265. First Court said it requires substantial factual and explicit evidence. Well, we disagree about it requiring substantial factual evidence. Then if you turn over, there's a denial that Lebanese law is the applicable law and limitation. And obviously that's an issue that needs to be determined as soon as possible. Is it DIFC law or Lebanese law? And then it said, should contrary to the claimant's case, it be found it is Lebanese law, it's denied that the applicable limitation period is 5 years. And then at 61.4, it's denied that the relevant date is the date of the shareholders' meeting, which is not set out at 265, although the date of 26th of May 2010 is stated in paragraph 8.1. And then the point it takes issue with is to say that the 5-year limitation period in fact runs from the decision of the shareholders on the 28th of July 2011. So that draws the battle lines, which is the relevant date, and that is a question of law in my submission. It's not a question of fact. We then have Professor Slim's report, which seems to start raising questions of supervisory fault. But again,
before you just go there, those dates, as they're put, the rival dates, are not on the basis of discoverability or knowledge. They are put on the basis that that is the relevant date when the loss and damage was suffered.
Correct.
So
correct.
When I asked Mr. Fisher as to whether or not there was any pleaded issue about discoverability, I think he said no, but it was hovering in the background, or words to that effect. What do you say about that?
Well, I say that's completely inadequate. If he wants to advance that as an argument before you, he needs to show you where he's pleaded that. And my lord, I would draw your attention to the fact that we have raised this for some considerable time. We actually set it out in terms at paragraph 17 of our skeleton argument. If I perhaps can just take you to that, because he's been aware of this for a long time. And we don't think it is pleaded out anywhere. So if I can take you, please, to paragraph 17, which should be in the first bundle, please.
Yeah, I've got that printed off, so not a problem. Yeah.
Sorry, it should be in the first, with too many skeletons in this case.
Yeah, there certainly are. Yes.
So it should be in our substantive skeleton, our first one in response to the appeal, which was dated the 26th of February 2020, and it's in paragraph 17, which should be at internal page 6. It's page 48 of the first bundle for those following in the bundle.
Yeah.
If you look at the top of that page, it says the short answer to this, as was submitted before the judge. So indeed, they've known this since we were before the judge, is that issues of limitation and loss do not depend on disputed factual matters such as concealment, the time at which damage was suffered, or inquiries as to the appellant's knowledge at any particular time. The appellants have not been able to identify any such issues which arise on the pleadings, which is unsurprising because there are none. So we set that out very clearly, and the footnote complains that of the very point that's been repeated to you in oral submissions, of this suggestion that it's hovering around, but that isn't enough. If Mr. Fisher is to seek to advance this point, he would need to take you to a particular part of the pleading where it is raised.
Yes, well, I'd highlighted that part of your skeleton and made the note alongside, is this right? But there we are. I have your submissions on it now, yeah.
There have also been, at various points, you were said, is there a real prospect that Professor Slim will be preferred at trial? Obviously, that is the test on summary judgment. It's not the test for preliminary issues. I'm sure you have that point, so don't suppose to labour it. There was also a point raised that Professor Slim has said something about supervisory fault, and you can't possibly determine that on the pleadings. Again, that isn't pleaded. And again, in some of our skeleton arguments, we've raised the point that a lot of what Professor Slim isn't pleaded. But again, in my submission, what is pleaded are the allegations that are made against us. And on any preliminary issue, the experts would be able to look at the pleadings and say, assuming this is proved, is that a supervisory fault as a matter of law or not? So we say that that is simply a smokescreen which seeks to persuade you not to deal with any of this as a preliminary issue. So again, you will see that Mr. Matter has set out the law on this. It's an issue of law as to whether the relevant articles of Lebanese law make this distinction, first of all, and then second, whether what's pleaded would fall within those provisions or not.
Yes. The only slight difficulty about that from your perspective is this, isn't it? That suppose the court were to find that Professor Slim is right, and there is a distinction to be drawn between, quote, supervisory fault, unquote, and faults of another kind. What's pleaded, they can each opine on, of course, at the preliminary hearing that you envisage. But the facts, of course, might turn out somewhat differently. But that's always a possibility, but it's one of the reasons why the Court of Appeal always expresses its warning, its note of caution about ordering preliminary hearings in case the facts turn out rather different.
Well, yes and
worth
no.
The risk, you say. Worth the risk, you say. Mr. Fisher says not worth the risk. That's what it comes to, isn't it?
But I say worth the risk in this sense. You will have seen that there are a few of these issues that are, in a sense, case management issues that need to be dealt with, before the full trial. So we'll come on to admissibility, but also the issue of whether it's DIFC or Lebanese law. That isn't a classic dispositive, but it is an issue that this court should deal with as soon as possible as part of case managing the trial, because both of those issues...
I see that. I mean, as a narrow issue, which law is it? I mean, if the court were to decide it was DIFC law, then, of course, we don't need a whole lot of other law at all. It's plainly a matter that ought to be decided in order to save parties time and trouble if possible.
Yes, but in a sense, if we got down to supervisory fault, it might turn out to be different. I mean, the court would still have saved a vast amount of time, and given that we're in that realm. But my submission very much is, when you look at this, my lord, there is no genuine reason to think that the court won't be able to determine whether there's supervisory fault or not, if it's relevant, because of course there's a whole issue about whether it's relevant or not. But if it's relevant, the court can determine that on the basis of the pleaded case. It's not right that the court still proceeds on the basis of what's pleaded, rather than trial being an opportunity to ask questions and then hope you make a case through the questions that are asked. So in my submission, that is a more illusory fear rather than a real fear. And of course, given what is said on preliminary issues, it's always the response to someone who's opposing a preliminary issue to say, well, you might end up with disputed issues of fact. That probably that is always said. Equally, the Court of Appeal in England, at least, have never said, well, we're now drawing a line. The risk of preliminary issues is just too great. You can't have preliminary issues anymore. And in my submission, when you look at the issues that we've very carefully selected and suggested should be tried early on, they all fall into the category of being dispositive, or alternatively of having a significant and beneficial impact on the end trial, because the claimants, my lord, have estimated this trial could take 6 to 8 weeks of court time, and we think that's an overestimate. But we think if it's case managed and these issues resolved as early as possible, then that will be significantly reduced, which can only be to the benefit of everybody. We don't subscribe to the view that, well, this is going to cost us a certain amount, so we should just get on and spend it regardless. That isn't modern case management. So I would invite you to find that is, in substance, a real threat, even though it's now sought to be relied on, no doubt because the claimants realise that on the face of the pleadings they are in difficulties. But as I say, supervisory fault can and should, if it's relevant at all, and if it's allowed to be an argument that's made, it can and should be dealt with on the basis of the pleaded case and on an assumption that the pleaded case is correct. Before I come on to admissibility, there was one other point that I wanted to just raise on the authorities. Again, I know you'll be very, very familiar with all the authorities, and I wasn't proposing to go to any of them, save to point out something that we've also said in our submissions, which is in relation to the case of Panasar. I don't know if you have that case to hand. But that, as we've said in our skeleton, is a very different case for two reasons. One, it was a case where the district judge had ordered of his own motion some preliminary issues at a case management conference. The court.
Mr. I got cut off about 3 minutes ago, and I've had to redial in. Where you had got to at that stage was that the issues were all either capable of being dispositive or needed to be taken at some stage, and the effect, therefore, would be of reduction in time and costs rather than any rerun. That was probably about 2 minutes ago. I don't know what I've missed since then.
Probably nothing terribly exciting. I was just saying that I wasn't proposing to bore you with going through the authorities on preliminary issues, so the S.A.L tests, or all the other tests, because I know you will be very familiar with them. And you've both been taken to the head note in the S.A.L. We also summarised it in our skeleton argument before the judge and set out all of the factors that are there. And we say that those are met in this case. And again, there's been very little focus from the claimants in terms of why those aren't met, beyond the repeated refrain of their factual issues to be dealt with, which I've been through in some detail, and the second point being that there will need to be an appeal. Now, obviously, with any preliminary issue, that is a possibility, but that isn't a reason in and of itself to not deal with these issues. And again, I would very much hope there wouldn't be an appeal, but if there is going to be an appeal, again, that can be dealt with in my submission relatively swiftly, and there's no reason why that wouldn't prevent, depending on what the outcome had been, etc., wouldn't prevent other matters being progressed. And we will now have a very experienced judge, Mr. Justice Field, managing this in the TCD. The final point I'd make is it's much better if there's to be an appeal on a point of law that's determined at an early stage, rather than after the parties have spent millions of pounds on a trial that then turns out was never necessary. So that also has to be balanced against that. You can't simply say, well, we win because there might be an appeal. I hesitate to say I hope there won't be an appeal, because experience shows in this case every single decision that's made seems to be appealed, but obviously it's also possible it might not be appealed. So that's dealing with appeal. The other case I just wanted to mention was the Panasar case, which you were taken to. That's a slightly more recent case. It's a 2020 case. As we've said in our supplemental skeleton, this case is completely inapposite here. It was a case, it's at tab 16 of the authorities bundle, page 440. The central issue on appeal in that case, if you look at paragraph 2, was that the judge made findings of fact that went beyond those necessary to answer the preliminary issues, and this amounted to a serious procedural or other irregularity. There was also a second problem with that case, which was that the district judge had made an order for preliminary issues without either of the parties having raised it. So simply cherry picking a quote to say treacherous shortcut, in my submission, that's no substitute for examining the substance of what's asked to be tried for as a preliminary issue. So, my Lord, unless there's anything else, we have set out in my submission a succinct summary of why we say the preliminary issue is appropriate in this case in our respondent's notice. It's at hearing bundle 1, page 42.
Yeah.
And we remain of the view that some of these issues are potentially dispositive. It could be tried relatively soon. The parties had agreed 3 days, relatively modest cost. Full trial is going to be very long, expensive and time consuming. We have also, my lord, raised the issue that's subsequently arisen related to COVID-19, which of course nobody knows how long the current restrictions are going to go on for. Plainly, this case, any final trial could only be heard in person. It's likely to be the type of trial that would be impossible. But again, we say that the preliminary issues, because they are based on pleadings and submission and expert evidence, again, that is something which we say could be dealt with whilst we're all in this period of uncertainty and lockdown. So in a sense, that's an additional reason. Now, then you've got the fact that the court won't need to hear any evidence of facts, and then obviously the fact that they're not going to ever be tried twice. So the issue really is whether you deal with them now or whether you deal with them. So then finally, I just wanted to deal with the issue of admissibility.
Well, before you go there, do you submit that this preliminary issue could be dealt with simply by telephone, or would it require a video hearing? And we've got witnesses in this case.
We do, and sorry, I should have made that clear, my lord. I would submit it that should be a video hearing. I know the courts in England, I've actually been involved in some of the cases already that have been heard, and I have done both submission and expert evidence examination, and they've both worked extremely well. So certainly I know the DIFC court was slightly more reluctant. We did ask if it could be dealt with by way of a Skype video hearing. But there is absolutely no reason why those hearings can't be effective, and indeed I've personally participated in them. But yes, in my submission, it would be preferable to have that through a video link, through Skype for Business, etc. And there's now obviously a
Excuse me. I don't think it's realistic to think of it happening by telephone. Video hearing, I think, is certainly perfectly feasible, particularly where you've got experts. It doesn't seem to me that would present a difficulty at all. One's always hearing witnesses by video, or at least one always was in the commercial court, and one's doing it in arbitration most of the time, albeit not the whole hearing usually. But I don't think telephone is workable. You simply lose the rapport and exchange that's necessary.
No, I agree. The very first hearing in England that was done by video was actually a case that involved experts on Kazakh law. So that's been extensively written about and was a success. So certainly there's lots of experience to draw on, and it has been reported to be successfully done with I think an ease that has surprised people. So yes, but yes, that would be the format in my submission. If we can't be there in person, which must be a possibility now, and certainly our submission is that these preliminary issues should be heard as soon as possible, not least given that the parties have already embarked on doing a certain amount of expert reports, etc. So we are halfway down the road, so to speak, in terms of having it dealt with.
I haven't checked the timetable that was set in the case management order by the judicial officer.
So if I could just explain, my lord, what happened on that is we were due to be hearing the preliminary issues during this week. So that was the reason that we asked for the appeal, because we knew everybody was available, would be dealt with at the same time. And in my submission, it's a shame that we aren't actually determining them rather than, but that was the period. So certainly in my submission, this could be dealt with, in the next couple of months. It doesn't need
It's
to go
about
off to
3
November,
months.
and it
It's
should be
about
dealt with
three-
as soon as possible.
It's
Obviously,
about
within
3 months.
reason, with appropriate time for people to prepare submissions and full Lebanese law reports. But again, I would suggest that it's listed on the basis it will have to be by video, and then if that proves that we can all be there in person, then by all means that may happen. But given that we don't know when, for example, experts might be able to travel out of Lebanon, people may be on different restrictions. But in my submission, it is something that can and should be dealt with via that method. So, my Lord, I propose then to move on to admissibility, unless there's anything else on the other two questions.
Well, whilst before I forget it, it would make sense, if I was with you on this, to have a timetable set up. What was previously ordered was for experts' reports to be filed within about a month or so of the order, and then supplemental reports about a month later, with a hearing to follow in what would then have been about 3 months' time. Perhaps your junior would like to formulate a few dates whilst you address me on the other matters, and then we can discuss those as a possibility, should I decide in your favour. But the other thing that might be worth thinking about in this context, and conscious of the possibility of an appeal from the preliminary issue if it was ordered, is whether it would also make sense to try and fix the date for the full trial in any event, so that everybody had it in their diaries, because one knows otherwise that dates fill up, and should there be a preliminary issue, should there be an appeal, and the end result required a trial still thereafter, it might make sense to have all that at least fixed on a penciled-in basis at the very least. Do you think you could think about that, and your junior could have a think about that, whilst you address me on the remaining matters, and then when Mr. Fisher addresses me in reply?
Yes, of course, we will get on with doing that. So if I can then deal with the issue of admissibility. Now, Mr. Fisher accepted that that needs to be resolved pre-trial, and therefore we simply don't understand the reluctance to this being determined as soon as possible. It's clearly something that needs to be determined. And in my submission, there's a confusion here between the question of admissibility and the question of weight or relevance. And obviously the Hollington and Hewthorne point is a point of admissibility that is raised on the pleadings. And when you asked Mr. Fisher what his answer to it was, with respect, he didn't answer the question. And now, obviously, we're not determining that today, but the court can and should and must, in my submission, as a matter of case management, determine whether these findings of the regulatory authorities are admissible at all. And it's much better that that is done as soon as possible and as part of the general preliminary hearing that will be taking place. It's the most cost-effective way, and it's something that we would have thought claimants would have welcomed, because they will then know precisely what evidence they do or they don't need to adduce. We don't accept that Mr. Fisher can say it's not necessary for them to prove that there has been money laundering. It is absolutely an integral part of the deceit claim that there was money laundering going on. And indeed, the whole way in which the claim is pleaded, and again he answered this without taking to the pleadings, is that there has, as a matter of fact, been money laundering going on. And if I can take you, for example, to paragraph 311 of the re-amended particulars of claim.
Yeah.
It's at page 167 of bundle 1.
All right, bear with me. Yeah. Yes.
So you will see pages 311 and onwards. There are assertions that money laundering did take place, and again, if you go back to paragraph 55.
Yeah.
Which is at page 106, this is where they rely on the FinCEN notices as evidence of the money laundering scheme perpetrated by LCB under the control of LCB's management. And then it says references in these re-amended particulars to money laundering are to money laundering scheme as particularised and disclosed in the FinCEN notice and the associated documents. So there can't be any doubt that the pleaded case is that did take place. And obviously what's relied on as evidence of that are the FinCEN notices. And then again, another reference that we found is 246.
Yeah.
Page 150. The claimants believe and allege that the requirements were not adequately verified. The claimant shall rely upon 246.1, the fact that systematic money laundering was taking place at the material time.
Yeah.
So in my submission, again, I won't go through, there are many other references. It couldn't be any clearer that actual money laundering is being alleged, and what is relied on in support of that are the FinCEN notices, and we say that is inadmissible. It's the Hollington and Heather Hewthorne question, which does need to be determined as soon as possible. If we're wrong, then they'll be able to rely on them. If we're right, they will have to adduce actual evidence. And it is obviously right that everyone knows where they are on that point as soon as possible. So, my lords, unless there's anything else I can assist you with, those are my submissions.
Yes, thank you very much. Let me hear from Mr. Fisher, and then we'll see where we go after that.
Thank you. So,
does anybody want to take a break, or realistically, we're likely to be through within half an hour or so, aren't we?
yes, I won't be very long.
In which case, I don't think, unless anybody feels they need a break, we'll carry on. No answers, so we'll carry on, please, Mr. Fisher. Thank you.
Thank you. I've really got three points to make. The first is to say to you, to invite you to revisit Steel and Steel and to apply those 10 points that are to be applied. Because we say with respect, I mean, there is a certain attraction, and as lawyers, we always want to some even drink to deal with and resolve legal issues, but we must be careful. And our submission is that when you apply each of those 10, really the balance comes through, the weight of this comes through against holding a preliminary hearing on any of these issues. I mean, we could go through them one by one, and I could identify, what we say, but I think my Lord has it. And so perhaps I don't need to do that. But I certainly do invite you to dispassionately go through each criteria and say, well, actually, just might the appellants be right here, that actually on balance, particularly when you get to the last one, the 10th one, are the benefits and disadvantages of a preliminary hearing actually going to be, in terms of the cost-benefit analysis, do they militate against holding a preliminary hearing? And with respect, we say that is the case. One of the problems, and this comes through, this is the second point to make, one of the problems that comes through the steel and steel criteria and applying them is that we really don't have a safe foundation for doing that on any of these issues for the reasons I've explained and submitted. But if we just take this point that's come into focus about the issue about whether there's an exception to, if there is a recoverable loss principle along the lines of our reflexive loss idea, if we have that concept coming through Lebanese law, is there an exception and how does that work? Well, can I just say it's a little bit harsher for my learned friend to say, well, you know, Professor Slim didn't deal with it. I mean, if we just have a quick look at what Professor Slim actually said and did, if we just go to his report for a moment, I'm going to take you to his report. I'm going to take you to paragraph 15 of his report at page 675.
Yes.
I mean, in fairness to Professor Slim, this report's not intended to be a full report on all issues of Lebanese law that relate to the claimant's claim, or the report that was required by the case management order issued on 18th of December. I will not discuss in detail the issues that would duly be addressed in a longer report. Where it is necessary for me to mention issues of Lebanese law that go beyond the two limited questions set out above, I will do so in summary form only. So, I mean, he's making clear that this is something that, you know, he's, as it were, reserving his position to flesh out much more on the state of Lebanese law. I mean, it's not such a surprise to my learned friends. It was Mr. Court Bowie, who was their expert some years ago, I think, who put into play this issue, which Justice Roger Giles picked up. And so we can't say we're taken, you know, totally by surprise and that it's not been dealt with. It's there. It's a factor. It's one of those things that just demonstrates the problems, the difficulties of having a preliminary issue, which, and I use the phrase again, can't be surgically dealt with. And that's the problem. We can't, let's put it a different way, we can't hermetically seal the limited facts and a limited point of law, which is really what the courts are saying should happen in where there is going to be a preliminary issue. It's got to be something that's confined. It's got to be hermetically sealed from the rest of the case. Otherwise, we are going to walk into trouble. And that's really what the courts have been saying. So that was the second point I wanted to say. The third point that I would make, and this is the last point, but we would say a very important point, and we do ask you to bear it in mind because it does go to the management of the trial and how things are going to develop. But the point is this: this is a case where we had a claim July 2016. We had preliminary applications. There's no complaint. That's the way of things, leading to a judgment from Justice Roger Giles in February of 2018. There was an appeal, and there were cross appeals, and neither party was happy, and so it came. And in fact, that's the last time we met in March of 2019. It took a year to get through the appeal process and to get a judgment from the Court of Appeal. So there was a 12-month delay. Can we just project forward a little bit if my learned friend and her case is right? I mean, we're in a situation now where it took quite a while from March 2019 to November 2019 to get the CMC listed, and we've used a further 4 or 5 months to have this hearing. If on my learned friend's approach this were to go for a preliminary hearing, we would. I hear my lord has asked for assistance, but the reality is we're probably going to be the summer or early autumn of 2020, and if it then goes off on appeal. And the reality is, I think it's fair to say both of us on both sides recognise that there's a real prospect. As my learned friend says, there have already been appeals from both of us. And so we could, even if we speed that up, we could easily find, if it takes the same sort of time, or even if it takes half as much time, we would be talking about this time next year, probably slightly later, going into the Court of Appeal. The reality is, and if it is a full year before the Court of Appeal were to deal with it, we would easily be looking at 2022. We could be dealing with 2022, 6 years after the claim was issued. And we would have put trial preparation on ice during that period, because we would need to look for trial preparation, we'd need to think about witnesses, we need to think about disclosure, and all of that gets delayed. And there is a real risk in terms of cost benefit that's just not worth a risk running when the benefit of the preliminary issues being determined, and they're very they're seductive in the sense that as a lawyer we want to get to grips with them, but they're not going to. If you come back to the S.A.L criteria, they're not going to press the button for you. We are at real risk of running into a Jarndyce and Jarndyce situation, and I know my law doesn't want that to happen, but really this temptation that my learned friend is putting before the court needs to be resisted. And as far as we're concerned, my learned friend spoke about the delay that we have delayed and why are we delaying. We actually want to bring this case to full trial, and we want to do that at the earliest opportunity. So my learned friends have been raising interlocutory applications, and these matters were in fact raised, as my Lord knows, before Justice Roger Giles a good while ago. We've not been making the interlocutory applications. We want this case to go to trial. We want to get the witness statements done. We want to get disclosure done. We want to actually get into a situation where the respondents, Deloitte and Mr. O'Fardel, are answering in court for what we say are their failings in the context of an exposure to money laundering and terrorist financing. And we want to bring that on. And so we're really not being difficult about it. We think it's going to have exactly the opposite effect. If there's an acceptance of an order for a preliminary hearing in this matter, all that's going to do is prolong the agony, and it's going to increase the cost. It's not going to deliver. And that's why I come back to where I started and say to you, apply the S.A.L and S.T.I.L criteria dispassionately, and you will come to a view. And it may be reluctant. And my Lord, I hear the sentiments. It may well be reluctant, because there is a temptation, but it's the right decision to say no to a preliminary hearing. And my Lord, that's how we put it.
Yes, I should tie myself to the mast and resist the siren song.
Yes, because it's just not going to deliver what my learned friend puts on the tin. That's why.
Have you had a chance to think about, and I hear what you say on timetabling, my immediate reaction to that would be that if, for example, I was against you and a preliminary hearing was ordered, as you say, realistically, that's unlikely to happen now, probably before the end of the summer. It might just happen in the summer. Realistically, I don't think plane flights are likely to be back to normal for quite a long time, but a video hearing would be possible when people are allowed to go back to work. And I suppose the question arises as to which judge would hear the preliminary issue, but one would assume it would be the allocated judge, Mr. Justice Field, would it not?
Yes.
And that would be the party's desire, so to speak, that the docketed judge should hear it. So it would depend on his availability as well as your own. But would there be any reason why one shouldn't fix a full trial date at the same time as fixing the preliminary hearing date for, let's say, a date in the if you're saying preliminary hearing early autumn 2020, fixing a full trial date for autumn 2021, which ought to allow for an appeal, and indeed preparation for the hearing should the decision at the preliminary hearing mean that the trial goes ahead. Would that be an objectionable course to adopt if I was against you on the preliminary hearing?
Well, objectionable is a word we wouldn't use in response. I think, can I answer in this way, that this is where video link and telephone link do have their limitations, because it's something that I would like in terms of dates, just to consult other members of my team and indeed our clients.
Yes.
In principle, my response to it is jolly good idea, and you should indicate that that's what you would like, if that's the way you decide, and then the parties would get together, having taken on board the indication you've just given. But we come back to it. We really say to you that we really think that the right order here is that you should make your decision, allow the appeal, and that we should then go back to our CMC orders, suitably adjusted for evidence and disclosure and resolution of other matters that are there to be resolved.
Understood. What I think I'm going to suggest, subject to anything Ms. Day wants to say on the subject, is that you should each take some instructions and then send an email as to what you say the future course of the proceedings should be, were I to decide this matter either way.
Yes.
And my experience, I regret to say, is that unless things are tied down fairly quickly, then dates just tend to go further and further out. It's partly a difficulty that arises in the DIFC with judges who aren't full time, because they have other commitments, and partly, of course, the problem of finding time both in the court and for counsel, and everybody has to be available for it.
Yes.
But the reality is that with everything moving slightly backwards, at least as a result of COVID, the sooner one gets dates tied down, the better. And if you were able to send me an email within the course of the next 24 to 48 hours, by which time I will have reached a decision and written the judgment, I hope.
Yes.
Then matters can be tacked on, so to speak, if not in final form, as an order of the court, at least in such preliminary form, subject to confirmation with the parties, as could lead to dates being sorted out in a way that makes some sense for everybody concerned.
Well, yes, and also liaising with the court, because we can come up with a wish list.
Absolutely, that's one of the problems. Is, as I say, it's availability of judge, availability of parties, availability of the court, and one needs to try and tie that down sooner rather than later. I mean, this is not this case is stale on any view, in the sense that the events in question happened a long time ago now.
Yes.
But one doesn't want it to get any staler than is necessary.
Yes, no, absolutely, and we see that, which again, if I may not miss an opportunity to say it, that's why we would like to get this case to full trial at the earliest opportunity.
Don't worry, Mr. Fisher, I have your point.
Thank you. Well, thank you very much.
Anything else you want to say, Mr. Fisher, before I just ask Miss Day on the last point?
No. Thank you.
Thank you very much, Mr. Fisher. Ms. Day, is there anything you want to say about the suggestions I've made so far as each party putting on an email its submissions about the future course of the action and fixing of dates on whichever decision I make?
There is, my lord, and indeed it ties in with the submissions that Mr. Fisher has made in response, because there is one thing that I think you should see that isn't in the bundle, which is that before the judicial officer, the parties had agreed sets of directions. So the directions themselves and the dates were not an issue. And the reason that's important is that the parties had agreed that the full trial, which the claimants want 40 days reserved for, could not take place before, off the top of my head, it was October, November 2021. Now, of course, that was assuming we had directions running from November of when the CMC was heard. So there was agreement last time, but it was agreed that even starting from November, we simply cannot get to a full trial until the very, well, at that point, we couldn't get to a full trial till the very end of 2021 because of the vast amount of disclosure, witness evidence, etc. Plus, I very much agree with you, it would be useful to have a date sooner rather than later, because blocking out 40 days in everyone's diaries is actually a very significant period of time. So I would invite that the parties can send you the agreed directions that were before the judicial officer, and also their suggestions for how those would be changed going forward. And we would welcome, whatever can be done. We're certainly not trying to prevent the trial being heard. It's simply that both parties recognise that that will take a substantial amount of time. Sorry, I've just been told there is actually page 65 of the bundle has the previous trial date that was agreed. Obviously, that will need to be adjusted.
I'm conscious.
And then in terms of the preliminary issue, however, we do say that that can and should be dealt with in July. My juniors helpfully scoped out some dates, looking at dates when Eid holidays are. And again, these would need to be looked at by everybody, obviously, but I just moot them for people to reflect on. So again, these are just suggestions, but for the reports to be filed on the 28th of May, responsive reports on the 25th of June, and then the hearing the week of the 20th of July. And in my submission, that is a perfectly workable timetable, and one that we should be aiming for if a preliminary issue was to be ordered. And indeed, that will obviously almost certainly be dealt with remotely, I suspect. Again, that can be dealt with without people having to go back into work if Skype for Business is used as a video or other options. As I say, that commercial court trial, which Mr. Justice Tier heard, was heard fully remotely, and I'm sure Mr. Justice Field could talk to him about how that was done. It really isn't difficult, and it can be done with everybody being remote.
Well, I think we all have experience of that now, and indeed, over many years we've had some witnesses dealt with remotely. So I don't see that as a problem. But by July 2020, I think it's. Who knows what plane flights will be like, even with reduced seating and so on. But a video hearing, one would hope, would be possible. But why don't you put your wish list in the form of an email? To the extent that you can agree that, so much the better. But I suspect the likelihood, the question is more than likely going to depend on Mr. Justice Field's availability rather than anything else. But we'll see. But can I require you to do that, both of you, as I say, your submissions for the future, bearing in mind and indeed enclosing a copy of what was previously agreed, although I'm conscious there is a draft order somewhere in the bundle on both bases.
Yes.
Can you do that within, where are we? Can you do that by lunchtime tomorrow, in 24 hours, or is that too soon?
That's fine from our end. Well, I think the orders probably are in the bundle somewhere. That's my fault. So we can just give you the page references to them, so you've got them. Well,
actually, I'd much rather have it separately with your email, if that's all right, as an attachment. It'd be easier for me to pick up.
Yeah.
And can I give you my direct email address? That's the easiest way for you to deal with it. You'll need to copy in the court. They're normally not very keen on me giving my direct email address, but I think it'd be much more efficient given current working conditions. It's jcook
at 7kbw.co.uk. Did you get that?
Yes, thank you.
I mean, you can always look it up if, but I don't. That will be the quickest way of getting material to me, and then, given that time, one can also liaise with Mr. Justice Field and so on, and then see what dates are possible. As you know, the way these things work is that whatever judgment I draft then has to go through the processes at DIFC, so that realistically you're not likely to have it before Thursday evening, I would think, and possibly not till next week, given the Dubai weekend. But we'll see. I would certainly hope to have something decided before we get that far. Good. Is there anything else either of you would like to add or feel you need to add?
No, thank you.
Not from my end either. So thank you for dealing with this again.
Yes.
Right. Okay. Is there anything that the court associate wishes to say to me that requires all of you to ring off and for me to talk to them about it? No answer from the court associate?
No,
Perhaps there isn't a court associate.
thank you, Sir Richard. There's nothing from my end.
Right. Okay. That's brilliant. All right. Very good. In which case, I just say thank you very much to both counsel and everybody else for making this work so efficiently. And you'll hear from me in due course, and I'll hear from you in due course. And I shall ring off now. And thank you very much indeed.
Likewise. Thank you very much.
Thank you.
Bye.
Bye.
Good, Sir Richard.